Sorry, another presentation in English, but my Spanish is not good at all. Okay, my name is Jerzy Bieluk, and I represent Poland University of Białystok. And I'm very glad I can present my paper in this conference. The topic of my presentation is legal mechanism of protection of family farms in Poland. And in Polish legislation, the family farm constitutes a specific example of agricultural farm. According to the Polish Constitution, to the Article 23 of Polish Constitution, the basis of the agricultural system of the state shall be family farm. This regulation imposes on the legislator the duty to support and protect family farms by implementation of legal regulation enabling and facilitating their development in both economic and social sphere. Article 23 of the Constitution reflects the will to apply preferential policy towards family farms, especially in opposition to big agricultural producers conducting their agricultural activities with the use of wage labor force. It's also a guarantee of evolutionary development of agriculture. The family farm, as the doctrine postulates, is a basic production unit in agriculture based mainly on the family members' labor. In the wider sense, Article 23 of the Constitution supports an agricultural model which is in opposition to the model of agricultural enterprise predominant in Anglo-Saxon states and visibly prevailing in Roman or Germanic states. The only legal definition of family farm in Poland, in Polish law, is the one formulated in the Act of Formation of Agricultural System. Under Article 5 of the Act, the family farm is to be managed by an individual farmer, and the overall area of its agricultural land must not exceed 300 hectares. Even though the word family is included in the definition, the members of the family are not mentioned in it. Thus, the family may also be managed, the family farm may also be managed by a single person. Under Article 6 of the Act, the individual farmer is defined as a natural person who is the owner or leaseholder of the agricultural property, whose overall area of agricultural land doesn't exceed 300 hectares, who is qualified in farming and has lived in the municipality where the farm is situated. And he has lived about for at least 5 years, and he has to manage this farm through this period. Since the 1st of May 2016, significant changes have been introduced in the agricultural land acquisition in Poland. Under the Act of Formation of Agricultural System, only an individual farmer may acquire land. The above restrictions don't apply to close relatives of the farmer, local government units, churches and religious communities. And then don't apply in the case of inheritance. Acquisition of agricultural land in other circumstances and by other subjects requires the consent of the President of Agricultural Property Agency, as a public legal person managing the agricultural property owned by State Treasury. Without the President's consent, agricultural estate cannot be acquired by, among others, legal persons, including companies, even those founded by farmers. And the President's consent is conditioned by several factors. And the consent for this acquisition of agricultural land is granted in the form of administrative decision, and this decision is controlled of the appeal in the appeal proceedings before an organ of a higher instance, is Minister of Agriculture, and in the proceedings before an administrative court. And the acquisition of the land is connected with some obligation to be fulfilled. The first one is the duty of running the farm that the acquired agricultural for at least 10 years from the day when it was acquired. And in the case of natural person, the farm is to be run by the acquirer. And the other limitation is the ban on disposal or transfer of possession to other subjects, also within the 10 years. And the Agricultural Property Agency is entitled to the supervision of these obligations. And the preemption right in the agricultural real estate constitutes another limitation in land turnover. In the case of the sale of the agricultural land, the tenant has the statutory right of preemption, and if there is no tenant, or he doesn't execute his right, the preemption right is statutorily ceded to the Agricultural Property Agency. And new restrictions, which was introduced on the 1st of May 2016, imposes the preemption right on the acquisition of shares and stocks in companies having agricultural land in their possessions. The only exception to this regulation is the sale of shares admitted to the public trading or disposal of shares to a close relatives or individual farmer. In this way, Agricultural Property Agency might receive shares and stocks in companies. And due to the fact that the above preemption right doesn't apply in the situation when the acquisition of the agricultural real estate takes place by other legal events than sales contract, the Act of Formation of Agricultural System provides an analogical solution, the right to acquire the agricultural estate. And the Agricultural Property Agency is entitled to do it if the acquisition of the real estate is the result of donation or exchange. And I think it's time for final remarks. The Act of Formation of Agricultural System of the 1st of May 2016 introduced several restrictions in the acquisition of the agricultural real estate. These restrictions target individual farmers who are under an obligation managing the farm for at least 10 years yet. The biggest limitation pertains to the possibility of land acquisition by legal person, who may acquire agricultural land only with the consent of President of Agricultural Property Agency. Moreover, the Agricultural Property Agency has granted the preemption right and the right to purchase shares and stocks in companies owning agricultural estate. Obviously, such limitations make the turnover of the agricultural real estate more difficult. They also hinder acquisition of the agricultural real estate by foreigners, which was the aim of the Act. However, these regulations are a source of serious concern about slowing down of positive tendencies in the alterations in the structure of farming land in Poland. A medium Polish farm is a little big, over 8 hectares. And these restrictions might impede accumulation of farming land and thus have a negative effect on Polish agriculture. Despite the declaration of support for family farms in Poland, the restrictive solutions might hinder the development of Polish agriculture. It may be observed that the mechanisms of family farms protection focus on the control of transfer of farming land instead of supporting these farms. Thank you for your attention. That's all. Thank you.